Okay, we're just going to wait another minute because people are all signing on right now.
Okay.
All right, I'm going to suggest let's get started. So welcome today to the Urgent Need Child Support Modification Workshop. My name's Christy Zlatkus, Esquire. I am the owner and the founder of Z Family Law. We are a boutique family law firm located in Rockville, Maryland, and we work on all issues related to family law, including divorce, child custody, child support, child custody and child support modification, prenuptial agreements, and divorce coaching. And with us today, we are extremely excited to have Chris Kunz. Chris is a friend of ours. He is with me on the Montgomery County Bar Foundation CLE committee, and he also serves as lead counsel for the Montgomery County, Maryland's Office of Child Support Enforcement. Chris, why don't you tell everybody a little bit about your experience?
Well, actually, I first started working for the Prince George's County Office of Child Support in 1989. And then in 1998, I came to the Montgomery County Office of Child Support, and I've been here ever since. For the last couple of years that I worked for Prince George's County, I became a contract employer with them. I also worked at a firm that did family law. And prior to 1989, which is a lifetime ago, I also did some private cases. But essentially, I've been working in child support for the last 30 years.
So suffice it to say, you know Maryland child support probably better than anybody. Would you agree with that?
I don't know about better than anybody, but hopefully I have a good knowledge of it.
Okay. So as far as I'm concerned, we have the expert here. He's been doing this for 30 years. He knows what he's talking about, and we know that child support is on the top of everybody's minds. As you can't possibly be surprised to hear, the coronavirus has dramatically altered the state of Maryland. On March 5th, Governor Hogan declared the coronavirus a pandemic and that there was a state of emergency in the state of Maryland. On March 12th, that's the first time that the Maryland courts issued any kind of directive limiting activities in the court. On March 13th, President Donald Trump declared that the coronavirus pandemic is a national emergency in the United States of America. On March 23rd, Governor Hogan closed all non-essential businesses. On March 30th, Governor Hogan issued a stay-at-home order requiring residents of Maryland to not leave their residences except for a narrow set of exceptions. And as of today, April 16th, the Maryland courts are closed to the public except in limited circumstances through June 5th of 2020. Chris, did you ever think it was going to be that long when this started?
No, I did not.
It's amazing what the backlog is going to be, but we'll get to that. With all of these closures, the coronavirus has ravaged the American economy, resulting in significant jobs. According to CNN today, since March 14th, 2020, approximately 22 million Americans have filed jobless claims. And Chris, when we were prepping for today's call, you had something interesting to say to me about how many unemployment claims there were before March 14th, 2020.
Yes, before about a month ago, before the virus, or before they started recording what the new unemployment claims were, there were approximately 12 million people already receiving unemployment benefits. So if you add that to the 22 million, you're at 34 million people getting unemployment benefits.
Well, according to the Baltimore Sun today, approximately 62,000 Marylanders have filed for unemployment since coronavirus reached the state. And according to the same publication today, tens of thousands of calls are placed to the Maryland Unemployment Office every single day. So even on their best day in Maryland, those who've lost their jobs through no fault of their own are eligible for anywhere from $50 to $430 a week in unemployment benefits. they can collect for up to 26 weeks. Now, Chris, you and I are in Montgomery County, Maryland right now. That's where we're sitting. Cost of living is high. Can a family survive, what do you think, on $430 a week?
I don't think so.
I mean, I'm glad it's there to be helpful, but these are really tough times. Mass layoffs and furloughs came suddenly as states enacted lockdowns of all but essential businesses, and multiple publications are reporting today that some states are expected to run low on funding for unemployment soon. So that small amount may not even be available if additional sources of funding are not found quickly. So where does that leave us, and where does that bring us now? Who is this webinar for? This webinar is for those who pay or receive child support. It is also for those who serve those who pay or receive child support. It is for those who have been furloughed, those who've lost their jobs, and those who have had their income significantly reduced due to the current pandemic. And here's what we're going to go over and what you're going to learn. The first thing we're going to learn is, what does Maryland law say about modifying child support? We're going to talk about what you need to know about modifying your child support order, what the definition of a material change of circumstances is and why you need to know that, and the importance of time in choosing when to file a motion to modify child support. And I want to put a big asterisk there and say this is the most important part of the entire webinar, to make sure you understand the importance of time. We're going to talk about what resources are currently available during court closures to help those who are self-represented and are having a child support issue, what resources are available for self-represented litigants, how the Office of Child Support Enforcement is proceeding, where you can find the forms that you need, and what to do with them once you find them. And then lastly, we're going to talk about what Z Family Law is doing to help this problem. And I'm going to ask you to stay tuned for a special offer from Z Family Law to assist families who are struggling from a sudden drop in their income. So let's start at the beginning. What does Maryland law say about modifying child support? Chris, do you want to take it from here about these two important sections in the Maryland Code?
Okay, so the legal standard for whether or not the court can enter an order modifying the existing child support order is that there has to be a, quote, material change of circumstances from the time when the order was entered. So it's not every single change, it's not a little change, it has to be a, quote, material change. And the second part of the code is that the court may not retroactively modify a child support award prior to the date that the motion for modification was filed. So the significance of that is that if someone is out there with no income or reduced income and they need a modification, they really should not wait till June 5th when the court opens. They should do everything they can to file a motion for modification now. And as will be discussed later in this program, there's forms available on the Maryland Court's website, and there's actually a Dropbox on the circuit court where you can actually file papers. My advice to anyone out there, as we will discuss, if you need a modification, you should file it now, because any reduction, any suspension in the support amount under the law can only start from the time the motion is filed with the court.
So I want to echo what Chris said and also emphasize that even further. And that also goes for anyone who believes that there needs to be a child support increase. The court may not retroactively modify a child support award. For those of you who are not attorneys, it's not a permissive thing. It's a hard stop. It is a wall that the court is not permitted to reach behind. And that is really significant. So if you lost your job in May of 2020 due to COVID-19, and you are at home, you're trying to take care of your family, you're trying to figure out the unemployment thing, and you don't think about or you don't take action on your child support obligation or the child support that you're receiving until maybe August. I don't know when the courts are going to open. Let's say that you wait that long. All that period of time, from March to August, the court cannot reach beyond the date that you actually file and provide equitable relief for that time. And I know I'm
So the arrears are continuing to accumulate until the order is modified.
So let's just take an easy example. Let's say your child support obligation, I'm going to take a super easy example. Your child support obligation is $1,000 a month. You lose your job in March, the end of March. April, May, June, July, August. That's $5,000 during a period where you may not have a job that you will still owe. And we'll get into what can happen to you and what can happen as far as you paying that. And the same thing if you are a child support recipient and you need additional help during that time, or your kids need things, the court cannot reach back. Material change in circumstances. We're going to get into this a little bit later, but a material change in circumstances, Chris, is a pandemic a material change in circumstances?
Well, if you lose your job because of the pandemic, then it would be fair to say that you have had a material change in circumstances and that your income has stopped. Or if you're furloughed for a lengthy period of time, a few months, your income has considerably decreased. So that, I believe, would certainly be a material change of circumstance. You know, if you usually make $30 an hour and it goes down to $28 an hour, that's not a material change. If it goes from $30 an hour to nothing, that's a material change.
Okay, so let's talk about some other questions, some big ones that my office is being asked. If I lose my job, do I have to keep paying my child support?
So the answer to that question is that according to the court order, you do, because your court-ordered obligation does not change until another court order is entered changing it. So if you lose your job, the court order requiring you to pay child support continues in effect until or unless it is modified. So if you lose your job, you should keep paying your child support to the extent that you are able to do so. If you are unable to pay the full amount, you should pay what you can. And there's two additional considerations here. Number one, and really the most important, is that the child support is for the benefit of your child. So it is very important. And the second thing is that if you are able to pay support and you don't pay anything, and if you eventually go before a circuit court judge on this matter, you're going to look a lot worse than if you paid what you could and paid something than if you pay nothing. Again, if you can't possibly pay anything, that's different. But if you can pay something or at least make partial payments, and you do, you're going to look a lot better by the time you go before a circuit court judge. If you pay nothing and the court says you could have or thinks you could have, then you're not going to look so good.
And I will say in general, every case is unique, but in general, what I say to my clients is pay what you can. If you are receiving that $50 to $430 a week in unemployment and you were able to get in that line and actually receive your unemployment, pay what you can out of that. If you have $0 coming in, but you have some room on your credit card and can order some groceries through Instacart, maybe you don't have dollars that you can hand over, but you can get your kids some groceries, do that. The more that you can do, the better you will look to a court. And again, every case is different, so that is not blanket advice, but you get the spirit of it. Pay what you can, do what you can. The order is there. If I lose my job and cannot keep paying my child support, literally cannot, I have $0 coming in, I have no savings, what will happen to me?
Okay, so under Maryland law, there's numerous things that can and will happen to you, most of which are by automated process without human intervention from the Office of Child Support. These are federally mandated enforcement tools, if you will, that are in the Maryland Code. And they include your driver's license can be suspended, your professional license can be suspended, medical license, license to practice law can be suspended, your state and federal taxes can be intercepted, your lottery winnings can be intercepted, your bank accounts can and will be garnished, your passport can be withheld, the credit bureau will be notified, a civil contempt action can be filed against you, and your COVID-19 stimulus checks from the government, which are just going out this week, can be intercepted if you have child support arrears. So all those things can and will happen to you.
And Chris, I got to ask the question because we've gotten it a few times in our office. If I lose my job and cannot keep paying my child support, will I go to jail?
So ultimately, that is a question, a decision that a circuit court judge has to make. However, you can only go to jail if you're found in contempt and if at the time of sentencing, the court determines that you have the present ability to pay what's called a purge amount to purge yourself of the contempt. If you, in fact, lost your job through no fault of your own during this crisis, then likely you will not be found in contempt. You can and will be found in contempt if the court concludes that you could have paid more in child support than you actually did. The court can then find you in contempt. However, even if the court finds you in contempt, the court under Maryland law is not authorized to incarcerate you unless at the time of sentencing, the court determines that you have the present ability to pay a purge amount to be released from jail. So number one, it's unlikely you'll be found in contempt if you lost your job through no fault of your own. And if you were found in contempt, it's unlikely you would be incarcerated if you had no money to pay any purge amount. However, I will caution this, that a lot of people get incarcerated because they fail to appear for the hearing. If you fail to appear for a contempt hearing, even though you may have a good defense to the contempt petition itself, if you fail to appear for the hearing, the court would issue a body attachment for your arrest. The sheriffs will go out and will arrest you, and you will be brought before a circuit court judge, hopefully that day if you're arrested in the morning. If you're not arrested in the morning, you'll have to wait till the next day. If it's a Friday, you'll have to wait till the following Monday. You'll go before a circuit court judge, and that judge will set bond to see if you should be released or not. So by all means, show up for the hearing. You have a much less chance of being incarcerated if you show up and you have a good defense than if you simply don't show up.
Thank you. Okay, next question. Is getting furloughed but not laid off a change in circumstances for which we can modify child support?
So the answer to this question is that it depends. If you are furloughed for 2 weeks, for example, chances are that's really not a basis at all for a modification. I've worked for the state for a long time. I've been furloughed several times, but each time I was furloughed for 2 weeks. And then the state let you prorate that 80-week pay period over a course of 22 pay periods. So it resulted in a loss of 2 or 3 hours of pay per pay period. That certainly, in my opinion, is not a basis for a modification. However, if you were furloughed for 2 or 3 months or indefinitely, in my opinion, that clearly is a basis for a modification.
Thank you. What should I do to protect myself if I'm the payor and I lose my job?
Okay, so I think that there's 2 things that you really must do to protect yourself if you lose your job. The first thing is to notify the Office of Child Support. If you notify the Office of Child Support, they can take steps to make sure that your driver's license is not suspended, that your bank account is not garnished, and other enforcement tools can be stopped if you notify them. If you don't notify them, then your license will remain suspended. Remember, some of those enforcement tools are automated. There's not someone in the Office of Child Support saying, I'm going to suspend this person's license. There's an interface between the child support computer and the Motor Vehicle Administration. Your license will be suspended unless we intervene to make sure it's not suspended. So you really need to notify us of your situation, and we can try to help in that regard. The second thing is that you should file a motion for modification immediately. And the reason you should file immediately is for the reasons we discussed previously, that the modification is only effective going forward. if you wait 2 or 3 months for the court to open and then you file, what you owed now and next month and last month that you couldn't pay will go on to your arrears, because the court does not have authority under Maryland law to make the modification retroactive to a period prior to the filing of the modification.
Chris, I want to jump in here and say, I want to go so far as to say, I have seen attorneys, Maryland attorneys online, telling people, oh, wait till the courts can open, nothing can happen anyway. Every time I see that, I cringe. To me, that is straight up malpractice. Yes, the courts are closed, but you need to preserve your date for modification. If you have any hope of having it, you have to file. Waiting is not good legal advice. It's terrible legal advice. So do not wait, file now if you have grounds now. Yes, the court's going to have a backlog. Yes, the court's going to take some time to open, but save your spot in line. Chris, if I needed to notify your office that I lost my job so these things don't happen during the pandemic, how do I notify you? How do I notify your office?
That is a really excellent point, because virtually every member of the staff at the Office of Child Support is on administrative leave. I go in 2 or 3 days a week for several hours, and I check my email. I look and see if I have any mail. I answer voicemails. But on any given day, there might be 4 people in the office. So that's a really good question. If you have our email address, you can email us. There's actually a statewide helpline at 1-410-250-1392. They should be able to tell you how to notify our office. If you have to, I'd come and put a notice under the door. There's not a really good procedure set in place as to how to notify us, but there generally are 4 or 5 people there on a given day. That's not many, and we're not all in the legal unit. But we are there. If you knock on doors or slide a paper under the door and we're not there, we will get it. So that's a poor answer, but there's not a procedure in place, actually, unfortunately.
Okay.
But certainly if people know me, they know my phone number, they can call me or they can email me or contact the office.
So what should I do if I'm a child support recipient and I lose my job and need more support? Okay,
so that's a good question. Can I just go back a little bit? I want to go back on the filing a motion for modification, if
sure.
I can. So we left it at, I said you should file a motion for modification immediately.
Yeah.
So the Office of Child Support, you can apply for a modification through our office. However, it will be much quicker if you file directly with the court, either on your own or through a private counsel. As stated, the courts are closed and our office is essentially closed until June 5th. We're not filing motions right now. So it's really important, in my opinion, that you file on your own. How do you do that? There are forms, there are modification forms on the court judiciary website. You can complete those forms. You can call the statewide helpline for information if you need help completing the form. Again, that's 1-410-250-1392. Additionally, the Montgomery County Self-Help Center attorneys are available between the hours of 8:30 in the morning and 4 in the afternoon, and they can be reached at 1-240-777-9079. They could give limited legal advice over the telephone, and they will. So if you don't have an attorney and you want to file this on your own, I suggest that you download the form from the Maryland courts. If you have difficulty completing the form, you dial either the statewide helpline or the Montgomery County Self-Help Center, talk to someone, and they will walk you through how to complete the form. Once you complete the form, there is a drop box at the circuit court where you can file the motion for modification. you will have to pay the filing fee, which I believe is $31. That can be by check made payable to the circuit court for Montgomery County. So you can fill out the form, you can write out a check, and you can drop it in the circuit court drop box. That form can ultimately be amended if you need to supplement information that should have been in there. If you talk to an attorney subsequently and it needs to be beefed up, it can subsequently be beefed up. But it's important to get the form in as soon as you can. So the other things that are important about filing the motion for modification is that once the motion is filed with the court, it needs to be served on the other party, which is in many cases the Office of Child Support, and in other cases, such as a divorce or a custody case, it would be the other parent. You as a party are not allowed under the Maryland rules to serve the other side. So you either have to hire a private process server or have a friend or family member over the age of 18 serve the other party. Usually you can pay the sheriff $40 to serve the other party or our office. However, currently it's my understanding that the sheriff is not serving people actively. So it's very important that the motion be served. You have service of process of your motion for modification. And it's during this pandemic, the question arises, how would you serve the Office of Child Support if you're closed? So the child support can be served by emailing and attaching a copy of the motion for modification to one of the attorneys at the Office of Child Support. We will accept service under those circumstances. So any party wishing to serve the Office of Child Support should contact our office, and we will give information as to our email and to serve us. Additionally, the person serving the modification papers has to complete and file with the court an affidavit of service. If that is not done, you won't get a hearing. So it's very important that an affidavit of service be filed with the court. An affidavit of service form can also be located on the Maryland Court's website. So it's very important that you file the modification, that it is served, that there is an affidavit of service, and lastly, what's very important is that you show up for the hearing. In many cases prior to this pandemic, it's very common for pro se folks without an attorney who file a motion, number one, not to obtain service on our office or the other side. And if they do, there's no affidavit filed. And even if they do everything perfectly, they file the motion, they have an affidavit filed, then they don't show up for the hearing and the motion will be dismissed. So you need to file the motion, you need to have it served, you have to file a motion, an affidavit of service, and you must show up for the hearing. And if you fail to follow any of those steps, your motion will likely be dismissed.
Thank you. Thank you for that overview. And for those of you scribbling notes at home, we will be going into each one of those steps in depth and showing you exactly where to find those forms in the next section of this presentation. So take a deep breath, pick up your pens, and we're going to go through that and walk you through that process nice and slow. But that was a great overview. So the next question we have, what should I do if I'm a child support recipient and I lose my job and need more support?
Okay, so there are hard times for everybody, unfortunately, right? So if you are the recipient of child support, you have the children, you're charged with taking care of them, you lose your job, what do you do if you need more support? Well, you know what? If the defendant also lost his job or was furloughed, you're probably not going to get that modification. The second thing is that if you have a child 12 or under, and the current support order you have includes a payment you made for daycare on a regular basis, you still might not get a modification if the other side, the other parent, is gainfully employed, because the court considers work-related daycare when computing or calculating Maryland child support guidelines. So if you, as a custodial parent, you lose your job, the other parent's working, by having lost your job, you no longer have work-related daycare. So you may, in fact, not qualify for a modification. If, however, the child is above daycare age and daycare wasn't previously included in the calculation for child support, you may be entitled to a modification. So what you can also do is the Child Support Administration website has a guideline calculator icon on the website. You can go to the website, you can click the icon, you can answer the questions, which largely are based on your income and so forth, and the calculator will tell you what the new support amount should be. So the answer to that question is it depends, but it's very possible that you may not get it.
Yeah, be careful. You may get it. There's definitely circumstances that go either way, but buyer beware. I would strongly encourage anybody who is a child support recipient who is considering this to speak to an attorney. We can help you run this.
Yes.
We can help you figure it out.
And you can go, again, you can have the guidelines calculated by the website if you have any questions. So actually, one question that did come up in this regard was, well, okay, so I lost my job, but I have a contract to pay daycare, you know.
You and I talked about that one.
Yeah. So in my opinion, I mean, I think the law is pretty clear that the court needs to consider work-related daycare. But, you know, if you're furloughed for 2 weeks or a month, I can see the court possibly still obviously including the daycare amount because you're going to be back to work soon. But if you're furloughed indefinitely or lose your job, I can't see the court including any work-related daycare. But that's my opinion. I've been wrong before. I'll be wrong again. But that, to me, is a hard argument to prevail upon.
Yeah, Chris and I had a pretty strong debate about this because I pointed out that a lot of my clients have to keep paying their daycare to preserve their child's spot in the daycare. Otherwise, they lose it. And even if they're furloughed temporarily or they're laid off and expect to get rehired when the state opens up again, they have to keep paying that. And is that a work-related daycare expense or not? I'd argue hard yes, but I absolutely could, like Chris, see myself being wrong. Been wrong before, could be wrong again. It depends on the jurist year before.
I think if there's a date certain that you're going to go back, the person's going to go back to work, I think the argument is stronger. But if it's open-ended, I think it would be difficult.
Makes sense. Okay, so your most important takeaway from this section of the presentation: modifications go back to the date of filing. If anybody is telling you, wait till the courts are open, I would say that Chris and I are unanimously telling you, don't do that, you need to file. Which brings us to what resources are currently available if you want to file. As you know, courts are closed to the public. Can you walk into the Office of Child Support Enforcement and get help with your filing? Chris already answered that. The short version is not right now. However, there is a statewide helpline you can call, and we have the number right there. I'm going to repeat it. It's 410-250-1392. Can you walk into the Family Law Self-Help Clinic and get help with your filing? Well, not right now. However, the Family Law Self-Help Center attorneys in Montgomery County, I don't know about the other counties. I wasn't able to get that information. But we do know the ones in Montgomery County will provide limited legal advice via telephone Monday through Friday between 8:30 a.m. and 4 p.m. at 240-777-9079. So most of the time, if you are a self-represented litigant, you are going to be getting these forms either from Chris's office or from the court or from the Family Law Self-Help Center. So where are you going to find them now? Your motion to modify child support, that's the first thing that you need to fill out. That, we have the links to all of these here. In your motion to modify child support, you're going to say to the court how much your child support or amount currently is, what changes have there been to either the children's expenses or your income, why these changes occurred. And that really does make a difference, because the court absolutely does care whether or not you quit your job versus whether or not you lost it due to a crisis such as the pandemic. And what relief you're seeking. Are you seeking an increase? Are you seeking a decrease? Are you seeking a stay? And Chris mentioned something earlier that I do want to repeat. The circumstances when you file it, which again, if you lost your job should be today, they may change. You may find another job before you actually get into court. And you want to make sure that you amend or supplement this motion in the future. That means if you file a motion that says I'm earning $0 right now, but come August 1st, you're employed again and your hearing before the court isn't until September 30th, you want to make sure that in August, when you get that new job, you are amending and supplementing this.
And I'll also state that if you do file now, but you get a new job 3 months from now, and your hearing is 3 months from now, the court can suspend your order for the 3 months from the time you filed until the time you get to court. So it's always important to file now. Even if you get a new job, your arrears will not accumulate if from the date that you file your motion for modification.
So the court has also helpfully given instructions for how to file your motion to modify child support, and we put the link to the instructions there as well. And then there's this thing called the domestic case information report that you need to file. Chris, can you tell them what that is about?
Okay, so actually our office doesn't generally file those, but it's basically a cover sheet that you have to state your name, the other party's name, the date that the order was entered, the amount of the order, if you believe the case is going to be contested. So that's a court form. Actually, generally that's for private attorneys. I see them all the time, but I don't generally file them. But it's just an information report. Demographics, if you will, information about the court order that you file with the court.
So more forms that you need, in addition to a motion to modify and a domestic case information report, if you're not going through Chris's office and you're filing it yourself, is a financial statement. A financial statement is a snapshot of today's expenses and income. It may also include a snapshot of assets in certain cases. So there are two different forms. One is the short form financial statement, and that's Maryland Rule 9-203B, and the long form financial statement, which is Maryland Rule 9-203A. Chris, what's the difference, and how does someone know which one to file?
Okay, so the rules require that if the combined income of the parties is $180,000 a year or more, which is $15,000 a month or more, that a long form financial statement be filed with the court. If the income is less than that, less than $15,000 combined gross per month, or less than $180,000 a year, then you can file a short form financial statement. So I think that the technical reason for the difference is that if the combined income of the parties is above $15,000 a month or $100,000 a year, over $180,000 a year, then the child support guidelines do not strictly apply. They don't apply, and the court will base the support on essentially the needs and expenses of the child. And the long form financial statement, which is about 7 pages long, goes into pretty much detail about different expenses for you and the child and the household, which assists the court in determining what the needs are for the child. Because again, the guidelines do not strictly apply. The court is granted great discretion to determine whatever support amount they feel is appropriate based on the needs of the child. And they get that information from the long form financial statement. So when it is prepared, it has to be prepared very carefully, and really with the aid of an attorney, I believe, would be very helpful. So probably most of the cases in the Office of Child Support are less than a combined income of $15,000 per month, but certainly not all. We have had many cases where one or both of the parties' income is, very significant, in the high several $100,000 a year range, even though we're a government agency. We do have a fair number of those cases, but the majority of our cases are under 15,000 combined income, and we use a short form, and we can use a short form. So that's the difference between the two forms.
So those are the main forms that you need. You need your motion, you need your domestic case information report if you're filing on your own, as opposed to going, and having Chris's office file on behalf of you, and you need your financial statement.
Let me just go back, if I can, just for a minute. So if the case is a case where the parties make a combined income of $15,000 per month or less, then the Maryland Child Support Guidelines, it's a state law. It was mandated by the federal government that every state, including the District of Columbia, which is not technically a state, obviously, have a guideline statute in effect. So if the income of the parties is less than $15,000 per month or $180,000 per year, the Maryland Child Support Guidelines are in fact mandatory, and that's important to know. Whereas if the income is above that, then the court has a great deal of discretion to determine what the support amount should be. So as I mentioned once before, that the Child Support Administration website has a guideline calculator on it. If your case is one which the combined income is $15,000 a month or less, or $180,000 a year or less, you can go to that icon. You can answer the questions. The icon will compute the Maryland Child Support Guidelines for you. The guidelines are a mandatory formula. The court is obligated to apply them, absent some limited circumstances. And if they deviate, they have to state specifically why they are doing so. So that's important to note. Whereas if it's a long form financial statement, the court has a great deal of discretion and can do, again, a wide array of things.
So once you have your motion, your financial statement, and your domestic case information report, you have printed them, you have filled them out, and you have signed them. The next thing you want to do is make a copy of all three documents. That might be you scanning them in and printing it out. I know it's really tough right now. You can't exactly easily go to Kinko's. There are free scanner apps on your phone. I recommend scanning them in and then as a PDF, emailing them to yourself, and then printing them out. That's a great way to get a copy with having tools that most people, have lying around the house. You need to have a copy for yourself because you also need to have a copy to serve. So what you do is you file those three documents with the court. If you're in Montgomery County, there is a drop box. It is outside of the front of the courthouse. If you are facing the front of the courthouse, which is the Maryland Avenue side, and you walk up as though you're going to walk into the courthouse, you'll see the drop box on the side to the left. You need all of these documents in an envelope, and on the outside of the envelope, you need to write family division. As the court is able to process these, the court will send you a summons. On the summons will be a date the summons was issued. For most summonses that are within the state, you need to serve the other side within 60 days of that summons. The way that you can serve the other side is, there are a few processes, but the most general are either by having another adult hand it to them, and as Chris said earlier, the other adult cannot be you. It must be someone else, or by sending it certified mail restricted delivery. When you do that and you have proof that you have done that, either the, I apologize, either the person who has handed it over, or you have the certified restricted delivery proof of it. Either you printed out the tracking number or you actually got a receipt from it. Then an affidavit of service must be filed. We have the link there for the affidavit of service form. If you do not serve the other party properly, or you do not serve the other party timely, it is very likely that your motion to modify will be dismissed. So pay very careful attention to service. If you have questions, call one of those hotlines, or you can always seek the assistance of an attorney. When you serve them, you must serve them with the summons, domestic case information report, the financial statement, and the motion. All of them, a copy must be handed to the other side. Then the affidavit of service must be filled out and filed. Only then will the next step be triggered. And the next step is the other side has the opportunity to file their answer. You may have to get an order for default, but your case will ultimately proceed forward. For today's purposes, what you need to know is fill out those 3 forms, make a copy, put them in an envelope, mark it family division, put it in the drop box outside the circuit court for Montgomery County. Wait for the summons. When the summons comes, serve a copy of the 3 things you filed plus the summons on the other side.
And again, I think the person would need to attach a payment to the clerk at court for the filing fee of $31.
Yes, I totally forgot that. You do. You need to pay the circuit court. You do.
So there's generally also a motion to waive fees. I presume that form may be on the court website, but it may delay things. If you can pay the $31, personally, I would just go ahead and do it. If you have a question about the motion to waive the $31 fee, I would call that state hotline number, which we went over before, which is 1-410-250-132, and ask them about, how to file a motion to waive fees with your motion. But again, if at all possible, I would pay the $31 just so you can have everything done and filed at the same time when you put it in the Dropbox.
Now, if you can't put it in the Dropbox, or you're following social distancing, or you cannot leave the house, you can also mail it to the circuit court. For Montgomery County, the address is 50 Maryland Avenue, Rockville, Maryland 20850.
So that is absolutely true. What I would do if I was going to file by mail, however, I would also attach a copy of the motion, and I'd put a little note to the clerk to please date stamp the copy and mail it back to you, so that you have evidence that the motion was filed and the date that it was filed.
And if you do that, you'll need to include a self-addressed stamp envelope for them.
Yes, sorry. True.
Oh, no, don't be. Hard to keep track of all these steps, even for us who've been doing this for a long time, when you're doing it in the middle of a pandemic. In other counties, if you're not in Montgomery County, Maryland, you want to call the clerk's office of that specific county and find out where their Dropbox is, or you can mail it there. Okay, so now that you filled out your forms, we talked about how do you file the forms in the courts close to the public, Dropbox, or you call them and see if there's a specific place they're being delivered, or if they're being accepted via email, or mail them to the court. The filing fee is $31. It is paid by check or by cash. Personally, I don't ever advise mailing cash, so check is ideal. Made out to the clerk of the circuit court of whatever county you're filing it in. How and when do I serve the opposing side? When you have the summons, you must serve them within 60 days, usually, of the date on the summons, if it's an in-state summons. And you must do so with all of the other documents that you filed. Now, Chris, we didn't go over this one. What if the opposing side is your office? How do we serve you?
I'm sorry, what if the opposing party, what? I didn't hear the question.
Is the Office of Child Support Enforcement.
Okay, so if the other side is the Office of Child Support Enforcement, you can email the attorneys and attach a copy of the motion to your email. And the Office of Child Support in Montgomery County, at least, will consider that good service. So that we would accept service in that regard. Again, our office is closed. How do you do that if our office is closed? Most attorneys, I think, in the county know my number or know where to get it, and my email, and the email of the other attorneys. But if you contact our office, again, most of the staff is on administrative leave. We have 4 or 5 people there on a regular basis, at least in the morning. Contact our office, and they will tell you how to contact the attorneys and have us served.
All right, so I've served the other side. I filed my affidavit of service. Chris, what happens next?
You will get a court date from the court, and you know, in so many of these cases prior to this pandemic, the defendants don't show up on motions that they have filed, and their motion is dismissed. So once you file your motion, you get the affidavit of service, you have the court date, make very sure that you show up for the court date and on time. If you do not, your motion will be dismissed.
So this is the hardest one to answer, at least from me. When will I get my relief?
Okay, so at the very latest, you should get your relief at the date of the hearing, which could be, 90 days out. Who knows when it is going to be, quite frankly. In cases through the Office of Child Support, the court enters a scheduling order which has a settlement conference date about 30 days prior to the hearing date. That's a date when all the parties get together, both parties get together with either an attorney or a legal assistant at the Office of Child Support. We go over all the numbers, we calculate the child support, and oftentimes a consent order can be reached at that time. But if you can't reach a consent at that time, then on the morning of the court hearing, there's another settlement conference at our office. Sometimes we don't settle the first time, and then we settle the day of the hearing. If you don't settle the first time or the settlement conference the morning of the hearing, we'll have a hearing, and then the court will resolve it.
So, and folks, I do want to let you know that there are some questions going on in the chat. We absolutely are going to answer them at the end. We will not answer case-specific questions. So if you're asking in my case, blah, 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 we're not going to answer that. But we will answer the questions that are in the chat and that are on the Q&A. So we see you. Hang tight. We're going to get there, and then we will answer your questions. Okay, so what I have to say about the hard part about when am I going to get my relief, we don't know when courts are going to open. As of today, as we sit here, it's June 5th. I don't know that it will be June 5th. It is. I really hope it is. But even once courts are open, Chris, I mean, how backed up do you see your office being? How backed up do you think it is?
Well, I see our office being incredibly backed up. There's going to be a huge pent-up demands to file motions for modifications. And our office, under the statute, the attorneys at our office, I'm an assistant attorney general. Our office, we do not represent either parent, the custodial parent or the non-custodial parent. We have to file motions for both the custodial parent or the non-custodial parent if in our judgment it seems appropriate. So a lot of custodial parents didn't understand that is a law, that we have to file for non-custodial parents as well if it appears a modification is appropriate. But what I suspect is that there's going to be hundreds of applications for modification that we have to go through, sort out, and file. So the way the dockets work is child support modification dockets are every Thursday, but they're capped. I think the cap it used to be 40 cases, and it may have actually decreased to 25 or 30 cases at the max. So we might have, say we have 300 applications. Even if we file on all those cases, it's going to be very spread out. because the court only puts so many cases on a docket. We do have a settlement conference about a month before the hearing. So some of those, 25 to 40 cases will drop off at the settlement conference. Others will drop off at the day of the hearing, and then we'll have a hearing on the remainder that don't settle. But it's going to be a huge backlog. And the thing is, in addition to the modifications, which of course this webinar is about, we also have lots of other work to be done at the Office of Child Support. We have new cases to file. We have, just a slew of activities to manage and get under control and get back to normal. And modification is simply just one part of that. And I can't imagine, what the court is going through, because, obviously they have to handle all these cases, and how are they going to handle the flood of cases? And I know that the court also has, I don't know how else to describe it, but sort of a bucket system. They can only put so many cases in the bucket on a given day before a given judge or before a given family law magistrate. And so, if there's a huge backlog of cases in the circuit court, obviously that's going to spread out those cases, months into the future. And the reason is it's just physically impossible to deal with all those cases, in a very short manner of time. Each case deserves its due. Each case is different from the other. A decision has to be made independently as to the facts of that given case. That's very important. That's what this justice system is all about. So you need a fair hearing, and you have to have time for that hearing. And the court has to allow time for each of those hearings. So if you have a huge backlog, it's just going to take time. There's no other way to get around it.
And Chris, would you agree with me that that's yet another reason to not wait to file?
Yes, you have to file. You have to file now because, under the bucket system, so to speak, the sooner you file, the sooner your court date's going to be. Because those court dates fill up. So you preserve your place in line if you file now. If you wait 3 months to file, you're 3 or 4 or 5 months farther down the road than you would be if you file now, in my opinion. So
I'm going to start this part by saying Chris Kunz was very, very kind enough to come and help us at Z Family Law on this webinar, teach all of you how to tell you what the Maryland law is and how you can help yourselves. So his being here is not an endorsement of our program. He does work for the state, so I do want to say that on his behalf, and we're really grateful to have him here. But Z Family Law, which is my law firm, we saw this as a huge problem. We see people who are stuck at home who are unable to file. Maybe they don't have a printer at home, and now is the time where you can go to a public library and print things, or go to Kinko's. Maybe they don't have a phone that has a scanner app or the ability to make copies. Maybe they've tried to call the hotline and can't get through. But either way, they need to save their place in line, and they need to preserve their date for modification right now. And as of today, Z Family Law is launching the Rapid Response COVID Child Support Modification Clinic. If a resident of Maryland has an urgent need to file for a COVID-related child support modification to preserve their date for retroactive modification, there are very few places to turn for help right now. And those places, while they're fantastic, they're overrun. You heard us say before, tens of thousands of people are calling the Office of Unemployment. They can't handle it. These phones are ringing off the hook. People need help. So the team at Z Family Law recognized this need, and we created the Rapid Response COVID Child Support Modification Clinic to preserve your child support modification date and get you in line for your child support modification for when the courts eventually reopen. When you purchase the Rapid Response COVID Child Support Modification Clinic package, you're going to secure our services for the limited purpose of filing for a child support modification on your behalf. Here's what the limited flat fee representation will include. We're going to file your motion to modify child support, asking the court to reduce or increase your monthly child support obligation. We will provide information to assist you with completing your financial statement, which will show your current income and detail the expenses that play a role in calculating your child support. When we receive the summons, We're going to send it to you. We're going to provide you a copy of that summons, as well as all the filed child support modification documents. We're going to provide you instructions on how to serve the other party or parties in your child support case, and we're going to keep you apprised as to the operation status of the court, so you will know when things begin moving in your case. The terms of this package are a limited scope representation. Our representation does not include serving the other parties, participating in discovery, going to court with you, or representing you in preparing for and attending trial. Merely to help those who are stuck at home, who don't have income to do a full-blown representation, and who need help saving their place in line. Maybe you're sick and you are quarantined and you can't get to the court to file this, or you don't want to have the ability, you can't get to Kinko's again to print it. We're offering this as a service. So let's talk about our fees. Typically, to initiate a child support modification case, our fees are close to about $1,500. However, we know that times are challenging right now for Maryland families, and we decided to charge flat fees for our work so that you know in advance how much this will cost you. So for this package, we're charging a flat fee of $500 for the Rapid Response COVID Child Support Modification Clinic package, plus the filing fee charged by the Maryland courts. This fee may be paid up front, but this means that regardless of how many of our lawyers or legal assistants work on your case, how many hours we spend working on our case, you're going to be charged one flat amount. You know how much it's going to cost. You'll have the option of securing additional services from Z Family Law, including arranging to have the other party or parties served. You must pay a process server fee if one is incurred. A 1-hour individual strategy session with an attorney to help you fill out your long-form financial statement if you're really having trouble doing it on your own. And a 1-hour individual strategy session with an attorney to review how to prepare for your eventual child support modification hearing. Those are optional add-ons. You certainly do not need to do those. And I do want to say, we offered this webinar as a service because we know not everybody can afford full representation or even partial representation. You're certainly not obligated to hire counsel, nor are you required to hire Z Family Law specifically. We've walked you through the process of how to file on your own. We've provided you the links to the forms that you've needed. We've provided you the phone numbers to the resources out there that we are available, that we know are available, even on a limited basis. If, however, you want assistance preserving your date by which the court can modify your child support, you can sign up for Z Family Law's Rapid Response COVID Child Support Modification Clinic by going to https://zfamilylaw.com/child-support-clinic. There are plenty of reasons to worry right now. Don't let filing for a change to your child support be one of them. Z Family Law's Rapid Response COVID Child Support Modification Clinic is a flat fee comprehensive service that handles every aspect of filing quickly and correctly the first time. If you've lost your job or been furloughed, you cannot afford to wait. Let us take care of the details so you can take care of your family. Again, here is where you can go if you would like to sign up for our clinic. So that is Z Family Law's, that is one of our ways of giving back. We, throughout this pandemic, have worked really, really hard to provide the community with resources. We have a COVID-19 resources page on our website that we are constantly updating. We provide resources on there for domestic violence victims, letting you know what is available in the area. We have provided resources for families, for children, for those suffering from mental health or addiction, and we're going to continue to keep those updated. We know that in this community, we are all in it together, and this is the latest way that we are doing our best to serve our community. So with that being said, we're going to turn and answer some of those questions that have been in the chat. Okay, so this was a comment to the panelists, not a question, and this was about the amount you can receive for unemployment. The $430 is gross. After taxes, it's about $360. So that makes it more tough.
The guidelines are based on gross income, however. That's important to note.
Yes, the guidelines are based on gross income. We do have a comment saying, is the Office of Child Support Enforcement pursuing enforcement during this time as diligently as before? And well, what question is that the stimulus checks might get attached.
Okay, so in terms of enforcing what we do, we file contempt petitions, but the court is not hearing any contempt petitions now until at least the beginning of June. So we generally have 2 contempt dates a month. So, the second contempt date in March, both contempt dates in April, the contempt dates in May, they're all going to be pushed way back. So we're not filing any contempts. We're not filing any motions. We're essentially closed. Again, I go in a few days a week, but we're really not taking enforcement action. However, I mentioned the enforcement tools earlier, including, the garnishment of these checks. That is by automated process without someone at the Office of Child Support clicking a button on the computer. The federal government has an interface with our computer. If someone is in arrears, they will intercept those checks. So to that extent, they will be enforcing it. With respect to all enforcement tools, the driver's license suspension, the garnishment of bank accounts, the credit bureau notification, yes, all those tools are in effect right now. They have not been suspended while the office is closed to the public. So you can contact our office and we can look at it to resolve it. But the automated tools are in fact still taking place, including the garnishment of the COVID-19 stimulus checks.
So there's another comment that they're asking us to write non-emergency on any non-emergency filings put in the physical drop box. So keep that in mind, folks. If it's not, you write that on the envelope.
And it's very important to note that while child support is obviously very important to the recipient and the person who's supposed to pay it, it doesn't fall within the emergency that the court is looking at when they're talking about that. Domestic violence, that's an emergency case. A criminal assault, that's an emergency case. Child support's very important, but it's not an emergency case that the court would hear prior to the court opening up on June 5th.
So Chris, another question we're getting is, if the Office of Child Support Enforcement is accepting service via email, will you also provide a declaration to that effect for the affidavit of service?
Well, the person serving us is obligated to file the affidavit of service. The person being served is not obligated to file something with the court, saying they receive service. The burden is on the person serving us to file the affidavit with the court. But you should contact us. I have a phone number and an email, and I try to be very responsive. And there's 2 other attorneys at our office, but it's up to the person serving us to file the affidavit.
Okay, so I do see one attendee with their hand up. We are going to take live questions. I do want to warn you that this is being recorded. So if you are going to speak up, you need to be aware of that and consent to the fact that you are being recorded so that everybody can benefit from the question and the answer. That answered that. Hand went down. If anybody else would like to talk, now is your chance. Please raise your hand and we will call on you.
Let me just say regarding service that even not in this pandemic situation we're going through, if an attorney calls me and talks to me and tells me about the motion, I oftentimes will arrange to accept service, but they need to contact me and talk to me and let me know it's coming. And in the past, I've pretty much done that on a regular basis with attorneys who have contacted me and asked me if they could do that.
Okay, seeing no other hands raised and no other questions or answers or anything else in the chat, I'm going to end the meeting now. Chris, thank you so much for helping us provide this important information to the residents of the state of Maryland. We truly appreciate your time in doing this. I know.
Thank you for having me.
Preparing. All right.
Thank
and
you.
those of you who have attended, thank you. We hope that you learned something from today's webinar. And if you take nothing else away, file now if you have cause to do so. Thank you so very much and have a nice afternoon. Everyone stay safe and healthy.
Thank you.